Okay, now we are live. Bismillah.
Assalamualaikum warahmatullahi wabarakatuh. Let's commence our talk with Ummul Furqan Al-Fatiha. Bismillahirrahmanirrahim. Welcome to Lextalk, Understanding Our Constitution 101. Brothers and sisters, distinguished guests, and fellow seekers of knowledge, it is with great pleasure that I welcome all of you to this enlightening event. During this captivating talk, we will embark on a journey to understand the essence of constitutional law, its significance, and its impact on our lives. Firstly, let me introduce to you our astounding speaker for our event tonight. Associate Professor Dr. Khairil Azmin bin Dato Mokhtar is an IIUM alumni in Bachelor of Laws Honours and Master of Comparative Laws. He was also graduated from University of Wales after completing his PhD in 2002. Currently, our professor is acting as the senior lecturer in Ahmad Ibrahim Kuliah of Law, and he is also one of constitutional expert in ICOL at that moment. Tonight, Professor Khairil, with his wealth of knowledge and experience, will shed light on the fundamental principles underlying constitutional frameworks and their challenges faced in their interpretation and application. As we embark on this intellectual journey, I encourage each and every one of you to actively engage with Professor Khairil to absorb his wisdom and to challenge your own perspective. Feel free to ask questions and take notes and participate actively in the enriching discovery that will unfold throughout the talk. Now, without further ado, I would like to invite Professor Khairil Azmin to take the stage and share his profound insight on our constitutional law. ويتفضل مشكورا.
Assalamualaikum warahmatullahi wabarakatuh. Thank you very much, Brother Aiman Firdaus, for the enlightening introduction. And I would like to thank the organizer of this Lextalk, the program, I think headed by your dear lecturer, Brother Muhammad Ridwan, and also all the members of the team who organized this talk. Basically, we are going to talk on some basic aspect of the Constitution, and but I would like to make the matter more lively, if we can relate to certain issues. So first of all, let me introduce myself. My name, as being introduced, is Khairil Azmin Mokhtar, and I'm teaching in the Ahmad Ibrahim Kuliah of Laws. And I think most of you who have graduated from Central or Fundamental CFS will join the Kuliah, inshallah, in the oncoming semester. So you'll be joining for LLB, honors, in our campus, inshallah, in Gombak. And hopefully by that time we can see you, and I'll be there, and maybe you can see me in live in Gombak. Okay, we are talking about constitutional law, and basically what is a constitution and why we have a constitution. So I'm going to touch on this matter at the beginning, and later on I'm going to show to you some basic concepts relating to the constitution. There are many concepts which relate to our constitution, but I'm going to focus on several basic concepts only, because in order to understand the whole constitution is going to take quite some time. So at the beginning, we're going to look at the basic aspect of the constitution, and hopefully from there you can relate to your surroundings, the issue that are ongoing in our country and perhaps even in other countries, because constitution is something which is lively. It is something which is dynamic. Okay, it is not some law which is, or a subject which is dry. You know, before we understand what move into more detail, let us ask first question: what is a constitution? Okay, before we move on, what is a constitution? So, what is a constitution? It may be defined in two aspects: a literal aspect or a general or specific aspect or legal aspect. Constitution, literally, it means a system that establishes the rules and principles by which an organization is governed. Okay, this is a literal meaning of constitution, a system that establishes the rules and principles by which an organization is governed. So when we talk about constitution, it can be constitution of society. For instance, when you join the IIU, you're going to have law society or students representative society committee, SRC, or even you have your own society in CFS. So all societies have its constitution. And there is also constitution for political party. As we know that in our country, there are many political parties. We have, for instance, Bersatu, PKR, DAP, PAS. All parties have their own constitutions. All right. And then we have clubs. So any organization has its own constitution. Okay. So meaning that each organization has a constitution. So this is a general meaning of constitution. But when we focus on a constitutional law, when we study law, the focus is on the specific or legal meaning of constitution. What is the meaning of constitution when you study constitutional law? When for law degree, it means a set of rules and principles that define the nature and extent of government that rule in the people in the country. Set of rules and principles that define the nature and extent the government that rule the people in the country. So in other words, when we talk of constitution, when we study constitutional law for law degree, it means the law which applies to the government of the country. Okay, a law which applies to the government of the country, and it tells us how the country is governed. Okay, a law which applies to the government of the country, and it establishes the administrative, the constitutional framework of the government in the country. So that is the meaning of constitutional law when we study. That is meaning of constitution when we study constitutional law. That is the rules of the government in a particular country. So like Malaysia, when you study constitutional law in Malaysia, you are studying the law relating to government of Malaysia. What is the law which rules the government of Malaysia? How Malaysia is governed? How Malaysia is administered? That is constitutional law of Malaysia. So if you go to Britain, perhaps you have friends studying law in Britain, they study constitutional law. So they study how the United Kingdom is governed, how the British government is being set up, who rules the UK, how government is formed, how government is made accountable. So it is basically the same principles in Malaysia, but it is the rules which are applicable in England. In the United Kingdom. So you study a different constitutional law. It is constitutional law, but it is the constitutional law of the United Kingdom. But Malaysia, we study constitutional law, it is the constitutional law of Malaysia. And therefore, our constitutional law is different from other countries, including UK. All right. So when it comes to law, we study constitutional law. That is the law relating to the government of a country, how that country is governed. Okay. So before we understand or we move into more detail what is constitutional law, we have to understand that constitutional law is one of the laws which come under the category of public law. I believe we have learned from your lecturers in CFS that law can be divided into two types, public law and private law. So constitutional law is a public law. It is one of the many public law. There are many other public law, such as administrative law, criminal law. Okay, so all these are public law. So constitutional law is one of the public law. Constitutional law is a public law because it is a law which applies to everybody. It doesn't take into consideration the personal aspect of a person. Whatever religion of that person is, whatever his race is, his age, it is applicable. So this is why it is regarded as a constitutional, it is regarded as a public law, because it applies to public as a whole. Okay, and then when it comes to another categorization, we can divide law into substantive law and procedural or technical law. Okay, so the most corpus of constitutional law is relating to substance of the law. Okay, certain part of constitutional law relating to procedure. For instance, how case can be taken to court in certain exceptional situations. Okay, so it is a little bit of constitutional law, but mostly it is it established the substance of the law relating to how a country is governed. Okay, so constitutional law, it is one of public law, and it also concerns about the substance of the law. Okay, so here now now we know that constitutional law is a law that tells us how a country is governed or administered. Okay, so this law is special. Why? Because this law applies mostly to the government. Okay, mostly to the government. When you study other law, for example, you study criminal law. Now, criminal law is about crime committed by individual or a group of people that is applicable to individual people like us. When you study law of contract, it is also about the people. You enter a contract, offer, acceptance, intention to create regulation, how a contract is formed. It is about us doing our thing. Okay, and when it's concerned family law, it is also about us. You want to get married, what happened when a couple would like to seek divorce, it is also about the people. Now, contract law about people contracting or making arrangement. Criminal law, it is about crime. And then whatever law you mentioned, it is all about the people. But when it comes to constitutional law, it is about the government. It is about the government. So this is how constitutional law is different compared to all other laws. All other laws, it is about the people, how the people should do this, how the people should do that, what the people can do, what the people cannot do. But when it comes to constitutional law, it is about the government, what government must do, what the government cannot do, what is the obligation of the government upon the people, how the government can infringe right of the people. So it is about government, government, and government. So this is something which is a must for any people who like to be leaders. If you want to be a leader, you want to be either a politician, you want to be an administrator, you must know constitutional law. Because it is about the government. So if you want to govern this country, you want to form a government in a state, you want to involve in the administration of the federal level, at the federal level in Putrajaya, you must know constitutional law. It is a must. Okay, and in fact, many of my students now are ministers, and some of them are current ministers. Okay, in fact, the former Menteri Besar of Pahang was also one of my students, but he's already retired by now. Okay, now coming back to constitution. Constitution, as you know, is a law relating to the government, how a government is formed, how government is established, how the government works, how it operates, how you form a government, what government can do, what government cannot do. So it is the constitution, what constitutional law is. If we apply the narrow meaning of constitutional law, it is a document having a special legal status which sets out the framework and principal functions of the organ of government within the state and declares the principle or rules by which those organs must operate. So every country has a document called a constitution. Okay, like if you look at other laws, when you study law of contract, there is a document called Contract Act. When you study criminal law, there is a document called the Penal Code. When you study family law, that is, for instance, the family law for federal territory. That is enactment of family law for Pahang, for instance. So for each law, there is a document. Okay, so constitutional law here refers to a document. It is not only a document, a legal document, but it is a law, a document which has special legal status. Why? Because as we're going to see later, one of the features of constitutional law or constitution is that it is the supreme law. Why? And because it is supreme, it has special position in almost every country. It is a special legal status. So constitution is a document which have special legal status, and this is the substantive part which set out the framework and principal functions of the organ of government within the state and declares the principle or rules by which those organs must operate. Okay, so this is the narrow meaning. Why there is a wider meaning? Let us look at the wider meaning. The wider meaning means the whole system of government of a country, the collection of rules which establish and regulate or govern the government. What is the difference? The difference is the second meaning or the wider meaning does not refer to a document. Okay, the narrow meaning, as we can observe, clearly states a document, but the wider meaning does not refer to a document. The substance is similar. The substance is constitutional law refers to law which relate to constitutional framework of government in a country. That is same, narrow meaning, wider meaning. But the difference is the narrow meaning says this only found in a document. Okay, this law is found in a document, but the wider meaning does not refer to any document. So what is the effect? The effect is for the wider meaning, constitution exists even there is no document called a constitution. So this is quite, it is exceptional. Okay, meaning that in that country there is constitution, there is constitutional law, but the constitution or constitutional law of that country is not embodied in one document. Malaysia, we have a document called a constitution, which is a federal constitution. In fact, in Malaysia, we not only have one constitution, we have 14 constitutions. Why Malaysia has 14 constitutions? One constitution for the whole country, which is called the federal constitution, and there are 13 constitutions. Why there are 13 constitutions? Because Malaysia has 13 states. Each state has its own constitution. So there are 13 state constitutions in Malaysia. Hence, in Malaysia, we have one federal constitution plus 13 state constitutions, and as a result, we have 14 constitutions. While the wider meaning says that there can be constitution and constitutional law, even there is no document called constitution. And this wider meaning is applicable only for a country. What country is that? The country is the United Kingdom. Okay, the United Kingdom does not have a written constitution. The United Kingdom does not have a document called a constitution, but the United Kingdom has constitution and has constitutional law. So this is the United Kingdom has what we call an unwritten constitution. So that is why we have a wider meaning to accommodate existence of the special, exceptional existence of the UK, which is a country that does not have a written constitution, which does not have a document or called a constitution. Meanwhile, for all other countries in this world, all governments, all countries have their constitutions, unlike Malaysia. All right. So now, by now, I hope you can understand. A constitution is a law which deals with government in a country. Okay. Now, I mentioned to you, Malaysia has 14 constitutions. One federal constitution, which is applicable for Malaysia, and there are 13 state constitutions. Each state has its own constitution. Pahang, Darul Makmur, has a constitution called the Constitution of the State of Pahang. Negeri Sembilan has a constitution called the Constitution of Negeri Sembilan. So that applies to all states in Malaysia. That is why when we go to Pahang, there is Pahang government. When you go to Selangor, there is a government of Selangor. When you go to Kelantan, there is state government of Kelantan. So you see, in Malaysia, we have one federal government, which basically apply the federal constitution, and then we have 13 state government, and each state government applies its own state constitution. Okay, so hence we can see that for each government there is a constitution. Okay, now let us move on to the next. Okay, why a country needs a constitution? So why a country needs a constitution? Can we have a country without a constitution? So now let us see. First of all, okay, the reason why we have a constitution is constitution is required in order to create and define power of governmental institutions. A constitution establishes the main bodies or organ of government in a country. Among the main institutions of a country are executive, legislature, and judiciary. And the constitution spells out how the bodies are constituted and regulated. Now, I think all of you know that you have the obligation to vote, right? So I think maybe some of you have involved in the previous general election, and some of you, inshallah, are going to vote in the oncoming state elections. So there are some states are going to have election in the oncoming months. We're not very sure. Perhaps in June, we're going to have state election. But that state election is going to be conducted only in several states, such as in Kelantan, in Terengganu, in Kedah, in Pulau Pinang, and then in where else? In Negeri Sembilan, isn't it? In a few states only, that not for the whole country. Why do you vote? You vote because you must choose government for the state. Okay, so you vote in the next general election in the state in order to decide who shall govern that state. So if you are from Kelantan, you're going to vote in order to determine who is going to govern Kelantan. So if you are from Terengganu, you're going to vote and decide who shall govern the state of Terengganu. Why? Because our country has three main organs of government, as we can see: the executive, the legislature, and the judiciary. So when you vote, you're going to determine who shall be member of the state legislature, and the member of the state legislature then shall decide who shall form the government of the state or the executive body. Okay, so this is how we govern. Where you want to find the provision? In the constitution of the state. All right. So how Pahang is going to create its government? In the Pahang constitution. How Kelantan is going to establish its government? In the Kelantan constitution. So the constitution tells us how the organ of government is established. Okay, so how the government in Kelantan is established, how the government is established, then you read the constitution of that state. All right. So the constitution tells us how the bodies are constituted and then how they are regulated. Okay, so if you want to, then you're going to understand basically the relationship between election and the legislature, and then the relationship between legislature and the executive. Then you know basically the effect of your vote. All right. So if you want to know how the government is established and what is the power of the organ of the government, then you must learn constitutional law. Okay, so the constitution in Malaysia basically established several main organs. All states have head of state or either a monarch or Yang Negeri, and then the executive body basically administer the country or the state, and then the legislature or the legislative body, the legislature makes law for the federal government or the state government, and then we have the judiciary. So these are the three main organs of government, and the constitution tells us how these organs of government are established. How do you create executive body? How do you create legislature? How do you create judiciary? Who can be member of the executive? Who can be prime minister? Who can be member of federal cabinet? Who can be menteri besar? Who can be the ESCO? Okay, how you can remove the government? also in the constitution. How you can table vote of confidence? How can you topple the government? How you can you change the government? All this in the constitution. Okay, and then legislature. Then we tell us basically who are the members of the legislature, who are qualified can be made to be members of the legislature. Can you become the candidate in the election? All this can be found in the constitution. And then judiciary also. Okay, who can be judges, how they are appointed, and the rest. So in order to understand who can be a monarch or sultan, and then who can be member of executive, member of legislature, member of judiciary, how they establish, all these are in the constitution. So that is why we need a constitution to tell us who is going to govern the country, how they are chosen, what actually are their powers, and how can we control their power, how they can be made accountable to the people. So all these are in the constitution. Okay, and then from here you can see, this is I just would like to show you quickly the relevant provision of the constitution relating to monarchy, and then executive, and legislature and judiciary. So obviously the Malaysian constitution was created in order to allow us to understand how the organs of government are created, how they're established, their qualification, the requirements, and then how they're being controlled. So as you can see, these provisions can be found in the constitution, and they are all relating to the many bodies of the government. Okay, so that is one reason why we need to have a constitution. The second is to regulate relationship between organs of government. As I have shown to you, there are three main organs of government, and then we have the head of state at the top. So you see there is a legislative body, there is executive body, there is judicial body. These bodies have powers. We have different people in each body. Members of the executive, members of the judiciary, member of the legislature. Three groups of people governing the country, doing their work. So the constitution regulate relationship between these three institutions. Okay, it is like your friend. Okay, you have friends. But there must be rules which regulates, which make the relationship between you and your friends amicable and good. What your friend can do, what your friend cannot do. Okay, so in order to establish a harmonious society. So this is also one of the purposes of the constitution, to regulate the relationship between the organs of the government. So if you want to know, for instance, what is the responsibility of Yang Tuan Agong? Okay, and then what is the responsibility of executive? And then what is the relationship between executive and legislature? Why we have prime minister in parliament? All this, the relationship between one student with another. Okay. Okay. Now another reason why you need to have constitution, is that to regulate relationship between the government and the people. So this is very important. Why? Because government cannot exist without the people. Government cannot exist without the people. Otherwise, what government can do? Because government must govern, but who government is going to govern? The people. So without the people, government cannot govern. And in fact, the government comes from the people. Government comes from the people. But the thing is, government has power. Government has power. So when government has power, the power of government have to be respected. Government have power, for instance, to make law. Government has power to make decision. So once law is made by the government, then the law must be obeyed by the people. Once the government made a decision, the people have to follow decision made by the government. Now here, the people have to obey law made by the government. The people have to obey decision made by the government. So this makes the people some sort of being controlled by the government. All right. Now this is acceptable because government govern, and in order to govern, government must have power. But our worry is that government abuse the power entrusted to them. This is what we worry of. What we want to avoid, abuse of power given to the government. Government must have power, otherwise government cannot govern. But our worry, what basically we want to avoid, is the abuse of power by the government. This is what our main concern. Therefore, the constitution regulates relationship between the people and the government. So it establishes the broad rights of individual citizens, or what we call human rights. A constitution declares or protects rights of the people. The rights cannot be taken away or infringed by the government. As I mentioned, government must have power in order to government. Government can make law, and the law must be obeyed by the people. Government has power to make decision, and the decision must be obeyed by the people. But if government makes a law and that law infringes rights of the people which been protected by the constitution, government is at fault. Government is wrong. If government makes a decision which is against the law or constitution, government is at fault. So here, we want to ensure government does not abuse its power. How do we determine? By looking at the constitution. Does the power of the government is exercised according to the constitution? If it is not exercised according to the constitution, then government is wrong. If the government undermine rights of the people, government is wrong. How do you find it? You look in the constitution. Find whether the government exercise the power according to the law or not. Okay, so this is very important because we want to protect the people from abuse of power by the government. Hence, we have a constitution which is supreme, which not only binding on the people, but the constitution which is above the government, above any person, including the Prime Minister, the Menteri Besar, the judges, all people, all organs of government are under the law and the people. All right. Okay. So here, as you can see, these are the provisions relating to fundamental liberties or human rights. So if any law made by the government inconsistent with any provision from Article 5 until Article 13, the law made by the government is invalid. It is bad. It is unconstitutional. It is against rule of law. Okay, if any decision made by government officer, by the Prime Minister, by Menteri Besar, anybody against the right protected under Part 2 of the Federal Constitution, then they are at fault. Okay, then they are at fault. In Malaysia, there are many governments. Okay, in Malaysia, there are many governments. How many governments in Malaysia? 14. There are 14 governments in Malaysia. Why there are 14 governments in Malaysia? We have one federal government headed by the current Prime Minister, and in the states, there are 13 states in Malaysia. In the states, there are governments. There are 13 states in Malaysia. Each state has its own government. Hence, we have 13 state governments. Therefore, we have one federal government and 14 state governments. Now, our country have many governments. Why? This is one concept that I'm going to touch on later, because we are practicing federalism. We are practicing federalism. In federalism, federal system of government is established, or federal constitutional framework is established. In a federal constitutional framework or in a federation, there are two levels of government. Government at the federal level, which is federal government, and governments at the state level, How many states in Malaysia? 13. So we have 13 state government. So there are many government. Why? Because we practice federalism or federal system of government. Because there are many governments, then the constitution regulates the relationship between the governments in our country. Okay, so you see, when we establish government, we must give power. In Malaysia, we have many governments, so we must give power for each government. Therefore, the constitution have to divide power. Okay, this is, as you can see, the second sentence here. The federal constitution divides power between federal government and state governments. So the federal constitution give some power to the federal government, and the remaining power is given to the state government. It is divided. Okay, so the constitution therefore ensure division of power between federal and state government are observed. There are things that federal government can do. There are things that state government can do, and federal government cannot interfere with power given to state government, and state government cannot interfere with subject matter to the federal government. The division of power is stated in the constitution, like Malaysia, where there is a federal system of government. Both federal and state governments are bound by the Constitution, and any issue or conflict between the government shall be resolved in accordance with the Constitution. You know? So this is the provision relating to division of power between the state government and the federal government. All right, as you can see here, we have power of the state government, power of the federal government, basically in part 6. Okay, the distribution or division of legislative power, division of executive power, division of financial burden. All right, okay, all right. And then this is another aspect, to proclaim identity and inculcate value. So the Malaysian Constitution says that Malaysia is a federal country. Okay, so it proclaims our Malaysia says creates a country which practices federal system of government and incorporates values. So we incorporate this concept. We have democratic aspect of our constitution, and then we have certain values. All right. If you see that some countries, they say that the Democratic Republic of Congo, for instance, and then some countries say the Socialist Republic of whatever, and then some countries say the Communist State of whatever. So this shows that certain countries adhere to certain value. All right. You want to adhere to democratic value, want to adhere to socialist value, and some countries say the republic, the Islamic Republic of Pakistan or Iran, some declare that it is a country which adhere to certain religion. Okay, so here one of the function of the constitution to express the identity and value of the community, and then of course some constitution also prescribe the national flag, national anthem, and other symbols. The constitution of a country is different compared to other country. Now there are similarities, but there are basic differences as well. Okay, like Malaysia, for instance, we establish our country as a federal country, and we incorporate in it the position of Islam as the religion of the federation. So this basically shows that in Malaysia, Islamic value is the value that must be given special status. Islam has special constitutional status compared to other religion. And for instance, 152 national language, which is Bahasa Melayu. Okay, this shows our identity. Okay, the identity of the country, which is Islamic, because religion is the Islam of the region of the federation, and in fact, almost in all constitution of the state creates similar provision. Islam is the religion of Negeri Sembilan, Kelantan, Terengganu, all states, except one state. And the national language is the Malay language. This also become the special identity. Right? For other country, they have different religion. For instance, in Ireland, they established the religion of the country is Catholic. And then you go to some other country, they said that they have some sort of Buddhism, Hinduism, depend on the country. Okay, but for Malaysia, we have religion of Islam, and the national language also different from one country to another. Like for Thailand, the Thai language, alright, and then for Bangladesh, we Urdu. For Malaysia, we have Malay language. So this established the special distinctive features. Okay. Okay, now I think I'm going to stop a little while, and then I give time for you to ask question, or I will respond to any question, either written or direct question, after I touch on this constitutionalism, constitution, and constitutional government. Okay. After that, maybe 10 to 15 minutes, I'm going to continue to finish the whole lecture, because I'm going to touch on certain basic concepts later. But before that, I would like to respond to certain comment or question. Is it okay, moderator?
Yes, Prof.
Okay, all right. So now, before I move on to the main concept of the Constitution of Malaysia, I just would like to explain to you the relationship between constitutionalism, constitution, and constitutional government. Okay, constitutionalism, constitution, and constitutional government. Now, the thing is, in all these words, there's a word constitution. Constitutional, constitution, constitutionalism. Constitution itself, and then you have constitutional government. Now, what are these things? How do they relate to one another? What is the relationship? What is constitutionalism? You know what a constitution is, because I have explained earlier. Constitution is a document which establishes the organ of government of the country and regulate the organ of government of a country. Okay, that is more or less the meaning of constitution, the law. Constitution is the law. But what is constitutionalism? Constitutionalism is not a law, it is an idea. Idealism, you know, conceptual. It is abstract, something abstract, not something which is concrete, like we can see, we can hold. Constitution, yes, we can see, we can hold, it is a document, all right? But constitutionalism, it is not a law, but it is an idea. Can you touch an idea? Huh? You cannot touch an idea, it is something in your mind, isn't it? If you have, you know certain philosophy, you know certain concepts, you know, you have certain beliefs, that cannot be whole, but it exists. Okay, so it is something which is abstract. Constitutionalism is the idea that government can or should be limited in its power, and its authority to govern depends on its observance of the limitation. This is constitutionalism. Now, why do I mention this? Because constitutionalism is why we have a constitution. Okay, constitutionalism is why we have a constitution. Why do we have a constitution? Because we want to limit the power of the government. They want to limit the power of the government. They want to control the government. Why do you want to control the government? Because we do not want the government to abuse its power. We do not want the government to commit wrong. That is why we have constitutionalism, to control the government. Okay, so the idea, constitutionalism is the idea that government can and should be limited in its power. Why you do want to limit the power of the government? Because the government power is limited. And what is the limitation? Legal. As long as it is legal, government is free. But it stops when it becomes illegal. Anything which is illegal, it is beyond the limitation of power of the government. Okay? And that its authority to govern depend on its observance of the limitation. So meaning that, yes, government has power to govern. But as long as the power to govern exercised by the government is done according to the constitution, then the government have to be obeyed and respected. That is, its authority to govern depend on its observance of the limitation. As long as the government does not abuse its power, as long as the government does not oppress the people, as long as the government does not victimize the people, then government can govern. But when the government abuses power, when the government govern not because they want to look after the people, then the authority of the government to govern is questionable. You see, that is why there are some people who are dissatisfied with their government. If you look at some other countries, even in Europe, for instance, if you look at the news, people are protesting in France, against the government here and there. Why? Because the people say that we do not want this government because this government has abused its power, has make decision which is against our will, against our wishes. The government has make decision not for our welfare and benefit. So they protest. Why? Because it relates to the second aspect. Authority to govern depend on its observance of the limitation. So we as lawyers, we as law students, want to ensure that government govern according to the law and constitution. And this is important. We as lawyers and as law students know how to take action against government when government has abused its power. What can we do according to legal means? How we can stop government from doing unlawful action? How we can declare law made by the government void if it is against the constitution? These are the knowledge that lawyers have. Lawyers know what to do when government commits wrong. And we perform our duty and action according to law. Okay, so this is why you study constitutional law, not only to know how government is governed, how our country operates, the duty of the government and the rest of the people, but also important, what we must know is how to take action when there is wrong in our country. That is, okay, so this is the idea of constitutionalism, to use the constitution to control the government. The constitution is used to control the government. So if you do not know the constitution, you do not know what is the mechanism that we can use to control the government. So some people say, no, I do not agree with government. Government has done wrong this, government has done wrong that. But you say that, why you say it's wrong? Which part of the law which it infringe? What right does it infringe? So if it is wrong, then what is the legal action could be taken? They do not know. All right. So we as law students must know what's the law which govern the government, so that we know whether the government is acting according to the law or not. And we must also know if government has done something wrong, how we can take action against government according to the law. All right. So this is why you have constitution and why you study constitutional law. Okay. Constitutional government is a limited government. In other words, a constitutional government is a good government. So you can have a bad government, you can have a good government. When you say constitutional government, it is a good government because it is a government limited in its power. A constitutional government is a government that observes the limitation placed by the Constitution and act in accordance with the letter and spirit of the Constitution. So constitutional government is what we want to produce. A constitutional government is one to produce because it is a government which acts according to law, which limits its power according to law. It is not an abusive government. It observes the limitation imposed by the Constitution and the law. Okay. Now let us come back to the diagram I've shown to you. You see, constitutionalism is the idea. So in order to constitutionalism is the idea of controlling the government. The constitutionalism is the idea of controlling the government. So how do we control government? We make a law. And we use that law to control government. What is the law that controls government? The Constitution. So hence we have, after constitutionalism, constitution. All right. So this constitution must embody within it provisions or mechanism which we can use to control the government, that we can use to take action against government. All right. So constitution is the concrete aspect. Constitutionalism is the abstract thing. It is an idea. So the idea is crystallized in the form of constitution. The idea, you turn it something concrete, a constitution, so that we can use it. And we use constitution in order to produce constitutional government. So why? Because there can be a bad government, or it can be a good government or constitutional government. So we want to have a good government, which is constitutional government. Hence, we use the constitution to ensure that the government obey the constitution, and as a result, if we succeeded in that duty, then we have a constitutional government or good government. Then you can live in peace. Okay, there's justice and there's peace, law and order. So this is the relationship between constitutionalism, which is an idea, something is abstract, which later being crystallized, as a constitution, which is something concrete. And this constitution then has the purpose of creating constitutional government. So we have to bear in mind that our duty to ensure that the government of the constitution is not during election, not after election, but at all time, from time to time. Whoever comes to the power, whatever party comes into the power, that's fine. But our duty as lawyers, we are non-partisan. We have to ensure that the government observe the law and constitution. Otherwise, we could up in tyranny or dictatorship. All right. So I stop here, and then I'll open the session for any question and discussion, maybe around 10 minutes, and then I will continue with the remaining lecture. Okay. I leave the session to Mr. Moderator for the time being to take up any question.
Thank you, Professor Khairil Azmin, for the first sharing session. Now we open the floor for the participant to ask any question related to our topic. The participant, you may share your answer, share your question in the Google form that will be shared in the WhatsApp group. Okay. Now we have received one question from Sister Alia Nabila. The question to Professor Khairil Azmin is, what are the constitutional safeguards in place to ensure a fair and independent judiciary in Malaysia?
Okay, so thank you for the question, Sister Alia. The question is relating to the provisions which establish judicial independence. Okay, and there are many provisions which deal with judicial independence. And in fact, there are many aspects of the Constitution which deal with judicial independence. As you know, for others who are not very well versed, the Constitution has three main organs of government: the executive body, the legislative body, and the judiciary or judicial body. Now, the thing is, each organ of government is going to check power of other organs. So judiciary is going to check power of legislature, and judiciary is going to check power of the executive. So if the legislature pass bad law or unconstitutional law, judiciary shall declare law as void. Okay, that is what we call judicial review of legislation. Now, executive body, judiciary is going to check the power of the executive. So if the prime minister or the minister or any member of government has done something wrong, then judiciary is going to review, again, judicial review the action and decision of the minister, of the prime minister, or anybody from the government, and declare that action or decision as unconstitutional. So this is how we control the government. One of the measures that we use to control government, judiciary, by exercising its power of judicial review the legislation, review the whatever the executive has done or decision that it made. All right. And if it is wrong, judiciary say it is wrong, it is unconstitutional. You cannot do this. Stop. Or declare the law void. Then issue of whether the judiciary is independent or not. Now, we are human beings. You're human being. The thing is, when somebody tells you you've done something wrong, you'll not be happy. You'll not be happy. So, the concern here is, how do we ensure that judges are free in making decisions? How do we ensure judges are not influenced in making decisions? Not influenced by other individuals, not influenced by political party, not influenced even by other organ of government. Okay, judiciary is only an organ of government. Executive body is very powerful. Legislative body very powerful because full of politicians. You know, they have support of people, and they have strong influence. So how do you protect judges to be independent so that judges can make decision even it protects one person against the whole world? How do you do it? You know, so this is a very difficult task, to be independent, to be brave, in front of a lion, for instance. This is just an analogy. All right. So the Constitution have provision. First, you make the judges independent in terms of finance. You see, when people have money, you know, they're happy. But when they do not have money, then they will look for money. Now, if judges are not financially independent, they incline to accept bribes. They incline to be influenced by bribe or any form of corruption. So there are provision which ensure that judges are financially independent. Enough money for judges so that they're not going to take any bribe or become corrupt judges. Okay, you see, but this is not easy. This is not easy. Why? Because corruption among judges are very some sort of sensitive issues. You see, I have PhD students from other countries who studied about how to make judges not corrupt. Because from his country, you know, he made comparison with other countries like in Turkey, in Korea, you know, because he said that the judges in my country, very senior top judges, several of them being charged for corruption and bribery. You see? So it's not easy to ensure that judges are free from corruption and bribery. So what is our what we can do? Make sure that they are financially independent. And actually, there are other provisions relating to ensure appointment of judiciary is made neutral. Otherwise, those in power are going to appoint judges who make decisions in their favor, especially those who are in power, you know. So they say that, okay, I would like to appoint judges, Mr. A, Mr. B, and Mrs. X. These are all his people. So when they become judges, if there's corruption charges against him, these judges say, no, he's not guilty. You know, why? Because they've been appointed by this corrupt politician, for instance. So this, again, you want to avoid. That is to make sure that the appointment of the judges are neutral and they're not being appointed because they are close to any quarters of politician. They are non-partisan. So you want to have judges free from influence of the executive body or legislative body or any other person. And there are several just provisions relating to removal. Okay, we want their safeguard so that judges cannot be easily removed. Sometimes people with authority, with power influence, judges make good decision, but because that fair decision is against some powerful people, then they want to remove the judges. This also we want to avoid. So the safeguard relating to appointment of judges, the safeguard relating to removal of judges, the safeguard relating to financial autonomy of judges. So there are safeguards in other aspects as well. All right. Or these are found in the Constitution. It is part of the Constitution. We have special, in fact, I can have deliver a special talk on the constitutional safeguard for the judiciary. And you see, in order to talk with current issue is going to take very long because I have to tell you what the rules are, okay, and what the problems with the rules, okay, and what actually is the issue that we have relating to the rules. It's going to take quite some time for me to talk on the issue because you have to know the basic rules first. But there are constitutional safeguard for judges in our constitution relating to appointment, relating to removal, and relating to financial affair. Okay. Any other question?
Thank you. Thank you, Prof, for the answer. Now we also received the second question from Brother Aiman Razak. The question is, what are the provisions vested in the Federal Constitution that deals with the situation of hung parliament after General Election 15?
Okay, thank you for the question. The thing is, hung parliament, you know. So here again, we can discuss about hung parliament when you understand about what is how to form government. Okay, the issue of hung parliament is related to formation of government. In fact, if you, I still remember, we faced this difficulty starting from I think 2019, 2020, during a beginning of COVID. Not only COVID-19, but we also problem that we mentioned hung parliament. Okay, and I've been invited in many talk by the television, and then my comment also appear in newspaper. Okay, talking about this matter, and in fact, I've been contacted from people from the government politician asking what should we do because we're not sure what we can do because it is what we call gray area because we have not faced such difficulties before. Okay, now let me tell you first about the framework, and then we're going to move on to hung parliament, and later on we can touch issue relating to the question. This is all about how to form a government. Okay, how a government is formed. In Malaysia, we practice parliamentary system of government or Westminster system of government. What is parliamentary system of government or Westminster system of government? Parliamentary system of government is based on Westminster system. What is Westminster? Westminster is a district in London. Okay, city of Westminster. The British Parliament is in Westminster. Okay, the British Parliament is in Westminster. So Westminster, that is the Houses of Parliament, actually ordinarily is a palace. It is a king's palace. It is near the riverfront. But the King Palace was on fire, and then after that they rebuilt and they make it Houses of Parliament. So this is the British Parliament. Now, why do we call it Westminster system of government? Because in this form of government, executive, remember the three organs of government: executive, legislature, judiciary. Okay, three organs of government. These are three different organs of government: executive, legislature, judiciary. They are separate. And they are independent. In Westminster system of government, in order to form executive body, the Prime Minister, Menteri Besar, you must first form parliament. Okay, you must form parliament. After parliament has been formed, then you can form executive body or government. So without parliament, you cannot have government. In order to have government, you must have parliament. Understand? So that is why when there is election, there is no government. When there is election, there is no government. When we're going to have election in the state of Kelantan later, when election is conducted, before election is conducted in Kelantan, legislature of Kelantan is dissolved. There is no Kelantan executive body during election. So how do you form state government of Kelantan? First, you make state election of Kelantan, and after that you get to establish legislature of Kelantan. After all members of legislature of Kelantan has been elected, then, only then, we can determine who can form government of Kelantan. Okay? The same goes for federal government. All right? Before we can establish federal government, you must have parliament. When all members of parliament have been elected, only then we can determine who shall form federal government. Understand? Huh? This is basically the rule. Why? Because the member of the executive must come from the legislature. Member of the executive must come from legislature. That is what we call parliamentary system of government. Why? Because the government come from parliament. Members of the executive come from the parliament. Member of the state government come from the state legislative body. Member of federal government come from the federal parliament. So this is why it is called parliamentary system of government. All right, that is the general rule. Okay, now let us move on to the next step. So we dissolve parliament. After we dissolve parliament, we have general election. This general election is to determine who shall be member of parliament. Okay, so now you don't have government. Just imagine, you don't have government. You must have general election. After general election finish, after we have determined who shall be members of parliament, all members of parliament be elected, then, only then we can decide or we can determine who shall be the prime minister and form government. So the power to determine who can form government after election rests with member of parliament. Okay? The power to determine who shall form state government after general election in the state is decided by a member of the state legislative assembly. So the state government of Kelantan is determined by a member of the state legislative assembly of Kelantan after election. All right. So that is the rule. Okay, now we move on to the intricate parts. If there is clear majority in the parliament, then it is not difficult to decide who shall form government, who shall be prime minister and shall form government, because there is clear majority. They say in parliament today, we have 222 seats. One party have 150 seats, which is more than half. So easily we can decide who shall be prime minister. Obviously, the person from party A. Same goes for state legislature. If there's clear majority of who control the legislature, then there is no issue, no problem to decide who shall form government. Let's say in federal government, party A have 200 seats. No problem, we can party A govern. In Kelantan, party X have majority. Let's say in Kelantan, there are 46 seats. And we say that 44 seats from one party. So that party can form government in Kelantan. No problem, it has majority. All right? That is when there is majority. And then the question, what happened when there is hung parliament? What is hung parliament? Hung parliament is a situation where no party has majority. No party has majority. For example, let's say in our country, our government today is based on hung parliament, because actually no party, no coalition has majority. But after that, Yang Tuan Agong said, you must do this and this and this. Then they managed to form what they call unity government. Okay, now let us look at hung parliament. Hung parliament is a situation where no party has clear majority. Example, they say that our federal government has 200, legislature, parliament has 222 seats. Okay, 222 seats. 100 seats belong to party A, 100 seats belong to party B, and 22 seats belong to party C. Nobody have dominant control. Party A cannot claim majority, party B cannot claim majority, party C also cannot claim majority. So there is hung parliament. we cannot form government because there is no clear majority. Okay, so this is what we call hung parliament. In this situation where politicians have to work among themselves. So this is, now it is beyond law. Okay, the solution is among politicians, among members of the parliament. So party A tackle party C to join, to make a coalition. Party B also tackle party C, want to form coalition. So if party A, for instance, managed to convince party C to form coalition, then party A form a coalition government or unity government with party C. If party B managed to form government with party C, then party B is going to form government, that is coalition government with party C. So the resolution for hung government is political. It is up for the politician to work out how majority can be formed at that time. So this is why there is issue when this government was formed from this Pakatan Nasional. PNC, we have majority, and then we have PHC, we have majority, and then say that, no, I have majority. So everybody claiming they have majority. And finally, Yang Tanagong steps in. All right. Okay. So why? Because these are discussion among politicians. So who enable to establish majority, then they are entitled to form government. So if a clear dominant exists in the legislature, no issue of hung parliament. But if no party have dominant control, no party have majority in the parliament, that is where we have hung parliament, and that's a little bit tricky to decide who shall form government. Okay, so I hope that will answer that question.
Thank you, Professor, for the answer. I think we can proceed with the second session of the sharing.
Okay, thank you. Now, let us move on. Okay, now I'm going to touch certain basic concepts of the Federal Constitution. Okay, what are concepts? It's not easy to understand, concepts. We have constitution, and then we have concepts of constitution. Okay, I just would like to inform you or make an analogy. Let's say we want to build a car. I want to build a car. You can build any car you like. But there's, I think you know what we call concept car, isn't it? Concept car. Concept car is a car which being built according to certain concepts. All right, certain concepts. So you want to build a car, but you have determined that car is built on what concept? Okay. Now, if that you want to build a car for a country which want to have a green environment, you're not going to build a sports car, So you're going to build a green car. So this is a concept car. That car is built so that it's going to be environmental friendly. And then that car is going to be economical. What else? That car is going to be a car which not to cater all people, but to cater student, for instance. So it is. So all these are concepts. So we have this concept. You want to make it environmental friendly, and then you're going to make it economy, and then you want to make it some sort of can be used by student and does not require high maintenance. So you build car based on the concept. As a result, we have a car which is environmental friendly, doesn't cost much to maintain, and basically it doesn't use much petrol. This car is different. Okay, this is one car. The thing is, if you want to make a racing car, it is different based on different concept. Okay, you want to make a fast car, is going to, you don't care how much petrol is going to consume. You don't care what effect it's going to have on the environment. And you don't care how much the maintenance is going to cost because it is a racing car. You're going to race it in the Grand Prix. So the car that is going to produce is going to be totally different from the earlier car. Okay, so the concepts followed, and as a result, you're going to have a product. So that product is based on certain concepts. If you have different concepts, you have going to have different product. Okay. Now, our constitution. Our constitution is created, is what we call molded based on certain concepts. So what are the concepts which mold our constitution? For that reason, I'm going to refer to the explanation made by the late Raja Azlan Shah, Sultan Azlan Shah. He was a federal court judge, in fact, he was a Lord President, and he made some very good decisions. So in one of his decisions, that is the federal court judgment in the case of Law Kwai Chun, Raja Azlan Shah stated that the supreme law of the land, is the federal constitution. The federal constitution embodies three basic concepts. So what are those concepts? One of them is that individual has certain fundamental rights. Okay, individual have certain fundamental rights upon which not even the power of the state may encroach. This is the first one. The second concept is the distribution of sovereign power between the states and the federation. And the third concept is no single man or body shall exercise complete sovereign power, but that it shall be distributed among the executive, legislative, and judicial branches of the government. Compendiously expressed in modern terms that we are a government of laws, not of men. So this is the description of the concept made by Azlan Shah in his judgment. Now, what are those concepts? In short, human rights, federalism, doctrine, separation of powers. And impliedly, at the beginning of the statement, Azlan Shah mentioned about doctrine of constitutional supremacy, and at the end of the statement, he impliedly refers to rule of law. So the three main concepts are human rights, federalism, and doctrine of separation of powers. Okay, and impliedly, he mentioned doctrine of constitutional supremacy at the beginning, and at the end, rule of law. Okay, I'm going to show you again the statement. Supreme law of the land, this refers to constitutional supremacy. The first concept explicitly mentioned, this refers to human rights. The second concept, which he expressly mentioned, is about federalism, or distribution of power, or division of power between federal and state government. And the third concept, it refers to separation of powers. Okay, and then lastly, say that you are government of laws, not of men. This refers to the idea of rule of law. Okay, so I'm going to touch very quickly, because actually it's going, conceptual things require a lot of explanation, but realizing that you don't have much time, I'm going to go through quickly each concept. Okay, first, constitutional supremacy. Constitutional supremacy, supreme law of the land, this refers to our constitution. Okay, in fact, we can say all countries in the world apply doctrine of constitutional supremacy, except I think 3 states. UK, because it doesn't have written constitution. New Zealand, because it is the constitution has similar states of ordinary law, and Israel, which also have does not give supremacy to constitution of Israel. It is regime, not a state, Israel. Okay, and then the provision relating to the constitutional supremacy is Article 4, Clause 1. Okay, supreme law of the federation, and then this is basically what basically constitutional supremacy means. The constitution stands supreme over all citizens, institutions, and a branch of the government, federal as well as regional. Okay, so in other words, the constitution is above. You see diagram usually Yang Tuan Agong. Ada Yang Tuan Agong, legislative body, executive body, judiciary. But actually above Agong is Federal Constitution. The Federal Constitution is above Kementerian Agong, Federal Constitution is above Conference of Rulers, Federal Constitution is above Sultan, Federal Constitution is above Prime Minister, is above all organ of government. So everybody subscribe the Constitution. And furthermore, the power of all organ of government derive from the Constitution. The Constitution basically gives power to them. If the Constitution does not give power to, for instance, Prime Minister doesn't have power. If the Constitution does not create office of Prime Minister, there is no Prime Minister in our country. So the Constitution establishes organ of government, Constitution gives power to the organ of government, and Constitution tells how this power can be exercised and how they should be regulated. Okay, so the Constitution is the source of power. The Constitution is the source of authority of the Agong, of Prime Minister, of federal government, of state government. All power come from the Constitution. That is what constitutional supremacy is. And obviously, by putting the Constitution above everything, all powers, all institutions, they have to observe and adhere to the Constitution. Okay, so the Constitution limits legislative and executive power of all levels of government in consonance with the idea of constitutionalism and limited government. So this is how you establish a limited and controlled government, so that they're not going to abuse their power. Okay, the second aspect is human rights. Individual has certain fundamental rights upon which not even the power of the state may encroach. As I explained earlier, we have government must have power. No purpose, or it defeat the purpose if government doesn't have power. Okay, defeat the purpose. So government must have power, but government must exercise power according to the Constitution. It must not abuse the power. So how do we determine whether the power exercised by government is abusive or not? One of the mechanisms is to check whether the power infringes or takes away right of individual or not. This is one of the rules that we can apply. So if the action, decision by the government, decision of the court, law made by the legislature, inconsistent with rights of individual guaranteed in the Constitution, it is unconstitutional and illegal. Okay, hence we have part 2 as I've shown earlier. So we use this as a benchmark to determine whether the law is good or bad. So if the law made by legislature is against any of the rights here, it is a bad law. So it shall be nullified. Okay, so this is how we control law made by the government. Okay, the third aspect is federalism. All right, first one is constitutional supremacy, second is human right, third is federalism. Federalism, distribution of sovereign power between the state and federation. So basically, it refers to a situation where power to govern a country is divided between two levels of government. This is very important, okay? Because here, we must know, no government have absolute control of our country. No government. Federal government is powerful, but it doesn't have complete control, absolute power. Okay, so our system of government is different compared to unitary system of government. Unitary system of government, the government has complete control over everything because there is no division of power. But in federal country, like Malaysia, the power to govern is divided between federal government and state government. All right, so federal government can govern the country, whole country, but not on all matters, only on certain matters. Okay, not on all matters. So state government have power to govern the state on some matters. All right, so this is how power is divided between federal government and state government. This is what we call federalism. And this is basically how division of power being constructed by a constitution. Okay, the constitution gives some power to the federal government and some power state government. So federal government power is not complete because only some power given to them. The remaining power given to state government. And when it comes to state government, the state government in West Malaysia have power, but more power given to Sabah and Sarawak. All right, and then there are the relevant provisions here. So this is how the power is divided between federal and state government. Okay, okay, basically the same idea. Okay, I think perhaps this is the last aspect on separation of power. Okay, Separation of power, no single man or body shall exercise complete sovereign power, but it shall be distributed among the executive, legislative, and judicial branches. I think most of you know what separation of power is. Okay, organ of government are three. There are three organs of government, and each organ has its own function. Okay, why? Because we want to avoid only one body or one person have control of all powers. Okay, our constitution has complied with this requirement, whereby it establishes at the federal level executive body exercising executive power, judicial body exercising judicial power, and legislative body exercising its power. And we have monarchy, head of state have certain role. All of them have power. All of them have specific role and duty. They cannot transgress the power of other organ. All right, they cannot transgress power of other organ of government. Executive body, what is the function? To make policy, to make decision, to perform action. This is executive body. Legislature makes law, table law, decide law, and makes law. And judiciary hear dispute. So executive cannot take the duty and function of the judiciary. Executive cannot exercise function of legislature, and basically the same vice versa. The same rules apply to each organ of government. And we can see here, this has been established by our constitution. Okay. Other concepts of in the present constitution that we don't have time to talk into detail include democracy. Okay. So we are a democratic republic, democratic federation, whereby we have the election, which allow the people to decide their representative, and their representative shall decide who shall form government. Parliamentary system of government, which I've touched on earlier, this system of government is whereby the executive must come from legislature. Now, why we mention this? We are not practicing presidential system of government. Okay, example, United States of America and Indonesia. In Indonesia, in the USA, in the Philippines, they practice presidential system. What is presidential system? The executive body is determined by the president, and the president is elected directly by the people. And the president and the its cabinet must not be member of legislature. So the idea of presidential system is totally the opposite of parliamentary system. Okay. And then we have constitutional monarchy. So we are not a republic like Indonesia, okay, like Singapore. We have a monarch who perform head of state. But when it comes to, for instance, Pakistan, it is similar to Malaysia, federal country, but it doesn't have monarch. It has a president. Okay, a president, but not president similar to US or similar to Indonesia. It is president like Singapore, okay, head of state only. And then the idea of check and balances. Now, principle of check and balances is very much related to separation of power, but there are also other mechanisms which have the function of checking and balancing the power of organ of government and checking the exercise of power by the government. Okay, so I will stop here, and I leave to the moderator for the maybe part of this talk. Thank you.
Thank you, Professor Khairi Azmin, for the wonderful and amazing sharing session. On the behalf of Malik Shura Council, Program Manager and Law Student Society, we would like to express our greatest appreciation to Professor Khairi Azmin for joining us in this sharing session tonight. In my point of view, there are three important ideas that we can derive from the session from Professor Dr. Khairil Azmin. Number one, the function of the Federal Constitution of Malaysia in managing and dealing with the relationship between the government and the citizen. Number two, Professor Khairil Azmin also explained about the basic idea and differences between the idea of constitutionalism, constitution, and constitutional government. And lastly, Professor Khairil Azmin have explained about the basic principle regarding Federal Constitution of Malaysia derived from the judgment by Raja Azlan Shah in the case of Law Koi Chun against Government of Malaysia 1977. To all the participants, you may feel the attendance link that will be shared in the WhatsApp group. Again, I would like to express our greatest appreciation and thank you for Professor Khayazmin for joining us in this session. Thank you to all. Thank you also to all participants that also join our program tonight. And I hope, inshallah, to all students, especially the law students, you may use this sharing session as a preparation to prepare yourself for the final exam, because one of the topic that will be discussed and exam is the basic and introduction of the Malaysia constitutional law. That marks the end of our program tonight. Thank you for all. Assalamualaikum warahmatullahi wabarakatuh.
And we have a photograph session.
No, Prof. Sorry.
Boleh on camera kejap ke? Kita ambil gambar sikit.
That's a short step lah. Nanti you can send to me lah.